we've all got a real treat coming up with this next speaker. Robert Steinbuck, who helped write what we've been talking about and what Mr. Turner referred to as the Foia Bible. I think the thing that I have really appreciate about Robert Steinbuck is his passion. It's undeniable. You see it come forth in every aspect of transparency. You know, it's one thing when we talk about it in private, but it's another thing when you see that passion and that fire in a Foia Coalition meeting, and just the knowledge and the depth of knowledge, and not only that, the willingness to always help. I mean, if there's citizens out there who have questions, he's always available, and we appreciate that. And we're in for a real treat here. We'll welcome Robert Steinbuck to the stage and look forward to your comments.
Thank you. Thank you all for having me here. It's truly a pleasure to be with you all who are so committed to transparency and access. I've been working with Joey for years, and even more recently, Joey and his partner Chip. We've been litigating cases on the Foia, and with my insistence, seeking every copper penny of attorney's fees when we succeed, because the only way you impress upon governmental entities the importance of transparency is by making them pay when they don't. And so Joey and I and Chip, his partner, Chip Sexton, succeeded in a case up there in Fayetteville, and we're seeking attorney's fees. I reduced my very generous rate of $1,000 an hour, because I'm worth every penny of it, to $250 an hour. We'll see whether the judge awards that or not. I take no shame in bleeding governmental entities that interfere with the rights of the citizenry, of the money they use to pay white-shoed, expensive attorneys in Little Rock to prevent transparency. And that was the case in the case that Joey and Chip and I had done. I'm sure they, well, we'll find out in our upcoming FOIA request response whether the city of Fayetteville paid their own exceedingly expensive attorneys. My guess is double of what we're seeking. But we'll find out, because that's the beauty of the FOIA. Just let me state for a moment, for those, if there's anybody here seeking attorney continuing legal education credit, you must fill out this form and give it to me before I leave. The other two forms is a review form. You don't have to fill it out, and an outline. You don't have to take it. But the one saying that you were here, you must fill out. So let's talk about some concepts of the FOIA. I always try to tell people the easiest way to make a FOIA request. Someone, I think it was Rusty, who just pointed out that often people will not make FOIA requests. They'll just write a letter with a bunch of questions. Of course, to be clear, FOIA is not the only means in which you get responses from governmental actors. So there's nothing wrong with writing a list of questions to governmental actors. The problem is they often won't answer those questions. And so the follow-up is often, the most useful follow-up is often a FOIA request. So I recommend making FOIA requests for records, because that's all you're entitled to. So so if you make a request, I seek the following records, and then list those records. It's helpful but not required to put a time limit going back, say, 5 years. Ask for those records to be sent to you electronically via the email that you sent the request in, or to be picked up on a flash drive, or be sent via a link to like a drive link. This way you don't have to pay for any copies. If the state entity says to you that they're charging you for labor, tell them that they can't. Too often, as was the case in another case of ours, that I have with Joey. I think it's a different case where the attorney.
Stop you just for a second.
Yeah.
Try this mic.
Is this one not working well?
It's bumping too much.
Okay, hold on. Too often, government actors will tell you that you have to pay for the, hold on. For the records, and they will invoke Section 109 of the FOIA. 109 is not a records request. Within the FOIA, those who drafted the FOIA 50 years ago put in, and this may have come later, I'm not sure, put in a section that said, if you want the government to create a record that doesn't exist, you can ask them. By the way, we don't need the law to tell us that, right? But nonetheless, in their wisdom, the legislators wrote it into law. And they said, since you can ask for something that they're not required to do, A, they're not required to do it, and B, if they choose to do it, they can charge you for the labor for doing it. In that provision, they actually added something useful, the legislators, which was saying, but if they charge you, they can only charge you a reasonable rate. Don't ask the government to create records. And inevitably, when you seek records, you're not asking them to create records, you're asking for existing records. So if the government writes you and says, oh, well, you'll owe us this for labor because this is under Section 109, almost invariably, they're lying to you. And I say lying because almost invariably, they know that 109 does not apply. It's not an accident that they tripped into 109 and thought for some reason that you owe them money. It's done to intimidate the FOIA requesters. When that was sent to Joey and me, I wrote back to the highbrow attorney in the white shoe law firm and told him I'd be happy to explain to him the difference. I'm not looking for a debate, because if we were to have a debate, we'd have it in court while I rack up attorney's fees. See Section 1, $1,000 an hour. See how that works? It's a virtuous circle. What was the other fight, Joey, that we got in with those attorneys? There was another element that they were making up some law on us, but I can't remember what it was now. Oh, yes, the reasonable specificity. This is the other defense that the governmental actors too often propound. There's an AG opinion out there somewhere, buried under a pile of dust, that relates the notion that you can make a FOIA request that is not reasonably specific. That is a true notion in theory, albeit one difficult in practice. Governmental actors too often interpret that as meaning that you can't ask for too much. Specificity has nothing to do with volume. Indeed, there's a case, Dougherty versus Jacksonville Police from 2012, that brings out that very point. Incidentally, Dougherty, it's an odd name, right? Partney, not Dougherty. Partney is a name she chose later in life. She changed her name. It's the word entrapped, spelled backwards. So you can tell that this is an activist. This is someone who's interested in pursuing a cause. She litigated that case. She's not an attorney. Through the Supreme Court of Arkansas and won. This is the embodiment of the people's law that is the Freedom of Information Act. I want to talk about, how many is it? 6 bills that are now acts from the last legislature that relate to the FOIA. Some of them more important than others, and just in order. So Act 56. I think this was, I forget who was the sponsor. It might have been Kim Hammer. I don't remember now. In any event, it's a simple bill, a small bill, but a perfectly fine bill. There was some question whether meetings could take place electronically, like this meeting is partially taking place. I had opined that it could, but the legislature confirmed that further established it, I should say, by enacting a law that says that. And so there's no dispute that public meetings could be held electronically. That dovetails well with Representative Flowers' bill requiring the recordings. I was a big supporter of her bill. I happen to be a Republican. As you know, she's a Democrat, and Mark is a Republican. But the point is, bringing that out, is the FOIA is not about left or right. It's about right or wrong. And so you can be a Democrat, you can be a Republican, you can be anything. It's about transparency in government. And everybody should be in favor of transparency in government. So that was a simple but good bill. You'll find as I talk about the bills that became laws that often what we have to do as FOIA advocates in concert with those strong legislators who support FOIA, or those legislators who strongly support FOIA, is pass bills that confirm what the law already is, because some government actor says, no, that doesn't say that. No, sky's not blue, up is not up, and down is not down. So we pass another law and another law. And I will discuss that now. Ben Motal is an attorney in Little Rock. He went in to take a look at a police report. Under the FOIA, you get to examine public records. That's one of the 5 things or so you can do. You can examine, have a copy made, make your own copy, who knows what else, I don't even remember. So he goes in, and they say, well, if you want a copy, it's $10, 1 page. And there's some law that supports that notion. He said, okay, I don't need a copy. I'd like to examine it under the FOIA. They said, sure. And he pulls out his phone, he goes to take a picture. No, 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 no pictures allowed. Wait, what? So he sues. Why? Because he's an attorney, and he can afford to sue for a $10 case, pay the $170 filing fee, and the other, have it served, and all of the other expenses, the same way I've done, the same way Joey's done, because he knows what is right. The trial court, to my surprise, ruled against him in an absolutely awful ruling from what is otherwise, what I understand, a pretty bright judge. But you know, while a blind boar will find a truffle every once in a while, often they won't. And this time, this trial court didn't. And it went up on appeal to the Court of Appeals, and the court said, well, of course you can do that. The fact that we're here is almost ridiculous. That's my commentary, not the court's. So I thought the issue was resolved until the city of Little Rock, because they never seemed to miss an opportunity to miss an opportunity, said, we're going to appeal it again to the Supreme Court. The Supreme Court turned down their appeal, but as those lawyers in the room would know, that's not a holding. That doesn't mean anything. So the city of Little Rock is sitting on this idea that we can still argue this. We can appeal it one day in the future. So we passed a law that said what the Supreme Court, the Court of Appeals said is law, is in fact a law. So now we got 2 laws that say the same thing. Hopefully the city of Little Rock will learn their lesson. I'm doubtful, but hopefully. Act 572. In every jurisdiction in this country that has a FOIA similar to Arkansas's, which is most, because it's based on the federal FOIA, and the federal FOIA, if you seek a record and the government refuses to give you the record, and then you sue to get the record, and the government gives you the record, then you're entitled to attorney's fees. Why? Because the law says if you succeed, you get attorney's fees. This notion is called the catalyst theory. A catalyst is a chemical you put in with other chemicals to create a reaction. Meaning you don't have to take a case to trial, get a verdict that says you get the records. If they come to you on the courthouse steps, the government that is, and says, you know what, you're right, here are the records, or here are most of the records, or here are the key records, anything like that, well then you won. And the FOIA provides for attorney's fees for those who win. That's the common language, not the specific language in the statute. Has never been in dispute. And indeed, attorneys throughout the state have have gotten attorney's fees in settlements in the past, for sure, until I sued. And then the University of Arkansas declared the catalyst theory is not the law in Arkansas after all. We stand alone amongst those jurisdictions in America, including the federal jurisdiction, in not recognizing the catalyst theory. Why? Because the federal jurisdiction, says the University of Arkansas, in all of their wisdom as an institution of higher education, because the federal FOIA updated their fees provision when there was a bad ruling on a different statute about attorney's fees from the U.S. Supreme Court. Of course, that U.S. Supreme Court ruling has no bearing on state law, so we didn't have to update our statute, nor did any state that has a similar statute do so. But nonetheless, the experts in the counsel's office in the University of Arkansas knew better. So we changed the law. We changed the law. By the way, since then, a trial court, our trial court, the case that Joey and I have in Fayetteville, said exactly what I said. Under the old law, guess what? The catalyst theory does apply. Surprise, surprise, what we all knew already. What my book has said as well, what Joey refers to as the Bible. My book said it all along. But the University of Arkansas knew better. So we passed a law. Act 658 says that if you're a government employee and a FOIA request is made for your personnel file, incidentally, personnel files are generally disclosable. Only the portion therein that is an evaluative record is not disclosable. But everything else is disclosable. But the employee is allowed to ask the AG to make, my words, essentially an emergency review to determine if there's anything exceedingly private in there that needs to be kept from being turned over. And so the Municipal League worked with a legislator whose name simply slips my mind to write a bill, a pro-FOIA bill that says, well, if you're only seeking the employee's salary, that could never be an intrinsically private matter. So that alone can't go for an AG review at the request of the employee. That's a good idea. The Municipal League has at times, this is an example of a time when the Municipal League has been FOIA friendly. At times they have not been. I've been working with them, hoping to influence them to a more FOIA-friendly position. Arkansas County Association has been FOIA unfriendly. And so I look with suspicion at any bill that they are supporting. Act 727 delays production of ballots pursuant to a FOIA request until the ballots are counted. That was a Kim Hammer bill. That makes sense. It's logical, so that's fine. And then Act 778, this started out as a bill from Arkansas Counties Association, and then we changed it, thank goodness, because the bill that they offered was a train wreck hitting a herd of cattle in the middle of a city. And so the bill, the act now says if you're seeking police video or police recording, after the first 3 hours of recording, they can charge you per hour of recording. Not per hour of labor to get the recording, but per hour of recording, $20 an hour. And that's a modest cost. So those are the big developments that we've had in legislation. Some legislation that I would like to see going forward. Of course, you all heard more than one comment already on Joey's sound bill about defining what a meeting is. I would also like to see two related concepts be enacted. Illinois, by way of example, other states do this, allow a citizen to go before the AG to get a ruling from the AG if they don't get records they seek and believe that the governmental entity is failing to comply with a FOIA. It's a method by which we can allow citizens who don't have the money or the skill to sue to get possibly some relief. Right now, legislators can make requests for opinions from the AG on any matter, and state agencies can seek opinions from the AG on FOIA issues, but citizens are, of course, allowed to ask, but the AG doesn't need to respond and typically does not. There's some notable and good exceptions to that, but we could require the AG to respond, as they do in other states, by setting up a separate department. If the AG doesn't want to do it, you can legislatively create a citizen review board that could have some power as well. Not likely to compel disclosure by the state agency, but you can turn the burdens around and put costs on the state or local governmental agency if they continue not to produce the records even after a citizen review board says that they should. Finally, in terms of legislation that I have in mind and something that I've worked on a lot with Dan Sullivan, I think Kim Hammer, plenty of others. Dan Sullivan, incidentally, is a very pro-transparency, pro-FOIA legislator, and I applaud him and others who work on these bills, because they're not, so to speak, the sexy bills necessarily, but they're the important bills. Universities across this country set up foundations for fundraising. These foundations are technically private entities, private nonprofit entities. To be clear, it's a private nonprofit entity because they file a piece of paper with the Secretary of State saying this is a private nonprofit entity that we have now created using governmental money and often housed in governmental resources. And here in Arkansas, as is the case in many states, the foundations claim they are not subject to the FOIA. After all, we're private entities. Even though we collect money on behalf of the state entity, when you go to give money to the state entity, they direct you to the private entity. They often use governmental employees, and they are sometimes housed on governmental grounds. But nonetheless, according to them, they're not subject to the FOIA. Some states have already ruled that they are. Some states have ruled that they are not. And of course, the easiest way to resolve that dispute is for us to pass a law making it clear that they are subject to the Freedom of Information Act. If we don't pass that law eventually, I'm sure Joey and I will bring a lawsuit and we'll get some resolution that way. But our lawsuits are stacked deep enough that it's not at the top of the pile at the moment. Let me just see what else we have here. The only one other thing that I wanted to mention relates to something I'm sure you've heard about. I didn't catch the earlier part of the meeting, but I already, as I said, endorse Joey's bill on defining what a meeting is, and that is because of a case that Joey had. Two cases, actually. The Wade case, and was the other one McCutcheon? Was it in your name? Yeah, the McCutcheon case, in which the Supreme Court provided a very muddied definition of what a meeting is. And that's unfortunate. I don't agree with the reasoning in that case. There are times in which I disagree with reasoning in cases, and I say reasonable people can disagree. There are times in which I think reasonable people shouldn't disagree, and I view those cases as broaching the latter more than the former. So I do think we need resolution, but I highlight the case to say that Joey did what Joey and I and certain other FOIA advocates do, is that we will pursue transparency through all means legal and necessary. So that's lawsuits, that's legislation, and that's education. And hopefully the last one I've provided some of today. So I'm happy to answer any questions that you might have. Ashley, did you have a question?
You might, you mentioned the bill that was a major tussle in the legislature about them trying to kind of open this door that they can charge for staff time. Kind of give us the how, because I think that we were on the defense, but we made a difference, because if you allow government to start saying you request records and they can charge for staff time, that's a major problem. And so if you even put a small crack in that door, tell us about that process, if you would.
I appreciate that, Joe. And Joe, amongst others, was instrumental in helping correct what was, as I said, a train wreck of a bill created by Arkansas County Association. Government is not entitled to charge you for labor if you make a FOIA request. Why? Because you've already paid for it. They work for you, and they have their crowbar in your wallet so deep it's coming out of the sole of your shoe. So there's no issue that you've paid for it already, and they want to charge you twice. They want to charge you again for doing the job that they are compelled to do already. And I have no doubt that a secondary purpose in that train wreck of an original bill written by the Arkansas County Association, that their intention was to introduce the notion that they could charge you for labor, because they put that in the bill. And we got that taken out. And that's critical. We can never allow government to charge you twice for what you own already. You paid for it once in your taxes. They need to provide it. If they have a complaint, they can dig up Governor Rockefeller and tell it to his bones, because that's the law. That's the way it is.
Jim Parsons, Bella Vista. What's the maximum charge they can do on a page of document that you ask for? Is it 35 cents or 25?
That's an excellent question. So if you seek physical records, which I recommend against, because I recommend you get all your records in an email or a flash drive, and you go print them out either at home if you have a printer. If you don't, go down to Kinko's or the like. And this way you can control the cost of printing. They're allowed to charge you for the cost of the paper and the cost of the toner, but not for the labor. So what's that come to? It's not $1 a page, but maybe it's more than a nickel. Maybe it's a quarter. I don't know. I don't know how to figure out those costs exactly, and I don't like to let them tell me what that is.
Robert, may I say
Yes, sir.
something?
Of course.
Change microphones again, if you will.
Okay. You want this one?
Yeah.
Okay.
The other one's better microphone, I believe.
Okay. Each one's better depending when.
Joey, I had a little experience with this one time, and Jim, Colonel Parsons at Harrison. I went into the courthouse to get copies of something, and the young lady that was a secretary there that knew she knew me and we knew the family, so we were on good terms. But she said, Dr. Lewis, we're going to charge you. We've all gotten together here in the office of the courthouse. We've all gotten, you know what I'm going to say, don't you, Liz? We've all gotten together and we've decided it's going to be 25 cents a sheet. And you know what I told her? I said, the law basically, and I think Attorney General's opinions will say this, I can ask you to document for me exactly what the cost of that is. What the ink is, the toner is, the paper is.
In a FOIA request.
Yes, yes. And I said, you're going to be in violation of the law if all of you get together and set a price. And they were trying to charge, I think, a quarter a page. I could have borrowed from my wife's checking account and probably paid that, but I didn't want to. But that's the kind of story of what I did. And you'll see this once in a while. Once in a while, I've come across this 2 or 3 times. When they say the secretaries, this is the secretaries now, not the judge or the court or anybody, we've gotten together and this is what we're going to charge. Thank you.
When government actors get together to help you out, be afraid. Be very afraid. I remember, I'll come to you, sir, in just 1 second. I remember when I was working where I currently work, and we had a faculty meeting, and the then dean said, oh, the secretary wants to make an announcement. Remember, we're a faculty full of law professors, but the secretary wants to make an announcement on the FOIA. All right. I wonder how that came about. You know, how would you like to have an open meeting to see how that came about? And she announced to us that we should destroy any of our emails that are no longer in use. Now, here's the thing. The FOIA is not a records retention statute, but there are records retention statutes. And destroying your records ain't part of it. So, room full of lawyers, and the secretary is advising us on what to do with our records. Sir, you have a question.
First of all, thank you for all the work you do on transparency.
Thank you.
There's a statute in the civil procedures.
John, could you come out? I hate to.
You want to grab that mic over there?
The audience at home can't hear.
Just wanted to get some advice. There's a rule in the civil procedures that allows circuit courts to certify those copies. $5, I think it's a $5 fee for certification. So if the case file is 10 pages, then they certify each page and charge you $50 for that. How does...
It's a good question. It's not exactly a FOIA question, but I happen to have a lawsuit on a similar issue, surprise, surprise. So the circuit court, when you make an appeal, you've got to take the record up from the lower court to the appellate court. And there's all sorts of charges. So it's not for the FOIA records, but it's for the records from the trial court. And they charge you like $1.25 for transcript pages. And the circuit court has been interpreting transcripts as any document in the file, including pleadings, briefs. Those are not transcripts. We have a case now before the Supreme Court. Another colleague that I work with, Chris Corbett, he would have been here, but he's not feeling well. He is a FOIA advocate as well. We have litigated FOIA cases. He has worked with me on that litigation involving the catalyst theory. Incidentally, he'll be running for state senate up in the Conway area. And we are suing for that issue of overcharging litigants for the cost of essentially copies of files. $1.25 per page for this, $5. It shouldn't be per page. It should be for the entire record. So this government will overstep its charging ability if it's allowed to do so. Government isn't bad. I'm not opposed to government. But governments are like puppies. You put them in a room with a bag of dog food, they're going to rip through the bag and eat the whole bag of dog food and then poop all over the floor. You got to mind them. You got to mind government, same way you got to mind a puppy. So there's a new sheriff in town. He's been here almost 20 years, and his name's Rob Steinbuck, and he's the author of the treatise on FOIA. So with that, I thank you all very much for your time. Let me announce for you that I am working on a new edition of the treatise. I'm hoping to have it to the publisher at the end of this year. My really wonderful co-authors, John Watkins, he started this book. The one you all have seen is the 6th edition. Obviously, John started with 1. Rick Peltz, the middle co-author, Rick Peltz Steele now, after having gotten married, started on the 4th edition. I started on this edition, the 6th edition, but with the promise to them that if I join them, I will take over the book in its entirety for the next edition, because Rick doesn't live in Arkansas. Rick and John don't live in Arkansas. Rick lives in Massachusetts. He's not involved in Arkansas law anymore. And John lives in Texas and is retired from teaching and practice entirely. And so the next edition, look forward to it. It will have only my name on it, and I'll be the one to blame for any errors contained therein solely. I really appreciate the efforts of each and every one of you that fights for transparency. We can't do it alone. It's with great citizens across the state who keep government in check that we are able to move forward. Thank you very much. Well, first of all, don't you have some copies of the book?
Yeah, most everybody in here has one.
Okay.
Given out.
Oh, okay.
I gave out 30 or 40.
Oh, wonderful. So if you are still in need of a copy of the book, It's on Amazon. This book is published by Arkansas Press out of Fayetteville. The new edition will be published by a national company. We're upgrading our publisher as well. I mean, don't get me wrong, Arkansas Press has done a fine job, but it's time to step up a little bit. So you can get it on Amazon. I think $34 or so is the retail price, and I'm happy to sign it for you, and then it could be worth $32. So thank you very much.